Xylosine.
Xylosine.
Oh, Shannon. Sorry.
Yeah,
I
we just
looked
talked
at
to him.
them and. Okay, I usually just,
Yep.
before I report it out, I always like to include the committee members to see,
Thank you.
if,
Yeah.
you're welcome. But to see what people
Yeah.
think, if you wanna go, because sometimes you might want it,
Yeah.
So usually I don't have an issue with that. Whatever you wanna do is fine.
Yeah. No, those are,
Okay.
We're a little better. It makes it moves to do it.
She's on the road. She said it's gonna take a few minutes.
yes. Mm-hmm.
So we read it correctly. It's like, we need to be, health purposes, we need to be, so we're reviewing that.
I'm there. That's okay.
Nice to show up.
Oh, I do that. I mean, who doesn't think of that? Yeah. But, I'm glad.
Well, you see an extension.
I was looking. I haven't talked to Monday. I was stressing during presenting commerce. Yeah, it was right there. Yeah. I could see it the whole time. I'm like, I just wanted to go get it. And finally, people kind of, the break slept. Yeah. I'm like, I know that's mine and it's. Right.
Good afternoon. This is the May 8th meeting of the Senate Judiciary, no, May 9th, excuse me, May 9th meeting of the Senate Judiciary Committee. Today, we are just going to be execing, and so I will take a motion to go into executive session.
So moved.
Moved by Senator Whitley, seconded by Senator Ward. Before we get started, there are a few bills that we are going to be holding. So I would rather just let everyone know at the very beginning, and we're going to take them up next week. The first is House Bill 307. Second is House Bill 313. The third is House Bill 400. Let's see, and House Bill 610 and House Bill 611. So we are going to be holding those bills until next week. Okay, the first bill that I would like to take up, because we have an addendum calendar that needs to get out, is going to be House Bill 639, and I recognize Senator Gannon for a motion.
I motion to ITL 639.
I second. Okay, is there any discussion? Senator Whitley?
Thank you. There has been a lot of conversation, I think, around this issue for years. And I think we are at a point where,
Yes.
we're at a point where our constituents have asked us, and they are very clear that it is time to end marijuana prohibition in New Hampshire and to legalize it in a way that's regulated, that can bring revenue into the state. So I'm not going to support the ITL because I think our constituents are asking us to do something. And I think the bill that we have before us, in addition to an amendment that I have, has been worked on by a lot of parties. I know the House really worked on it in a bipartisan way. It came to us, it wasn't perfect, but it was something that everyone, including a whole host of stakeholders, had worked on and felt like it was bringing us to the next step and moving us forward. I think a piece that had really been missing is the opportunity to obtain revenue. Revenue is something that we desperately need in New Hampshire, and we have to think creatively about how to create or how to bring revenue into the state. And I think this bill not only would bring revenue to the state, but it would recapture revenue that is fleeing our state and going to our neighbors, that are often just right over our border. So, New Hampshire is this island of prohibition, and that means that money is being spent right over our borders. And so this bill was an opportunity to capture those dollars. In addition to being broadly supported by our constituents. I mean, over 70% of our constituents that were recently polled support this. And I just think it's pretty rare to have an issue or a policy that is so broadly supported. And so I think not acting on that, I think sends a pretty strong message to our constituent. I think this bill had a lot of merit in addition to the revenue. There were a lot of harms that have been identified because of marijuana prohibition. I think this bill would address those harms. I think establishing a responsible and regulated market for adult use, I actually think that would, be good for our public health, and that, at this point, we have an unregulated market. We have no idea what's on our market. I think the black market is a scary thing, and I think this bill would go a long way to, establishing a highly regulated and responsible market for adult use. In addition to reclaiming those tax dollars that are just flowing out of our state into our neighbor state. So I think it's a mistake to ITL this bill. I had hoped that we would able to at least have a discussion about it, discuss the potential amendments that I had raised. And so I'm sad to see this motion.
Okay, are there any further comments? Okay. Seeing none, we have a motion of ITL. All in favor say aye.
Aye.
Any opposed?
No.
Senator Gannon, would you like to put this one to the floor?
Yes, ma'am.
Okay. Okay, next we are just going to go through these numerically. The first one we have is House Bill 68, and I am making a motion of re-refer.
Second.
Second by Senator Gannon. I just think with this bill, we just need a little bit more time to look at this bill so we get a better understanding of exactly what this bill is doing. So I would just like to retain it. So are there any further comments, questions? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Is there a motion for the consent calendar?
So moved.
Okay. Is there a second? Second by Senator Gannon. Okay, is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Opposed? Okay. I'll take this one. I'll do the blurb from Matthew. Okay. Next, we have House Bill 114, and I'm going to make the motion of ITL.
Second.
Seconded by Senator Gannon. Any discussion?
Yes,
Yes, Senator Chandler.
thank you, Madam Chair. This is our second look at this almost identical bill to one that we considered before. I know that I was hoping that we would look a little bit differently upon it this time from this committee. I think that the problem as it was described when we last discussed it remains a problem, and this is a potential solution. It is only one of what I think many solutions that are needed, but mental illness and is we are at a crisis. We know that folks, particularly teens, are suffering from mental illness, and this would give us an opportunity for teenagers to access care without consent. And I think that is, we do it for in other areas, and I think it would be very important to do in this area as well. I was hoping this committee would look favorably upon the bill, and I wish we could do that.
Okay, thank you. Are there any further comments? Seeing none, we have an ITL motion. All in favor say aye.
Aye.
Aye. Any opposed?
No.
Okay. I will take this one. Okay. Next, we have House Bill 287, and we also have an amendment. So I will move on to pass on House Bill 287.
Second?
Seconded by Senator Whitley. Okay, let's take up the amendment first, which is amendment number 1710S. And Mr. Lehman, do you want to walk us through the amendment, please?
Yes, the amendment removes, narrows the definition of drug paraphernalia, or narrows the definition of things that are being moved outside the definition of drug paraphernalia. As originally drafted, it would have characterized as not drug paraphernalia implements that are used, can be used in the production of large-scale quantities of hard drugs to measure the purity of drugs being either produced or sold, or generally have assisted people engaged either in manufacture or sale of narcotic drugs, either in small or large quantities. My understanding from the senators was obviously the idea of a fentanyl test strip that could save lives is an idea that has merit, but they didn't want that to bleed into the production and sale or commerce in drugs. And so as drafted now, it would allow fentanyl test strips to be used. It would allow fentanyl test strips to be in the presence of the drug. Originally, there was a draft proposed, we were just walking through with some people from the Attorney General's office that would have said you can't have the test strips and the drugs in the same place, but that obviously destroys the whole purpose, and they agreed with that expansion. So this would basically allow the test strips to be used, hopefully to save people's lives, prevent overdoses, prevent people from taking drugs that are represented to be heroin or cocaine, but actually consist of or contain fentanyl. And at the same time, not allowing any changes in the law encourage manufacture or sale of drugs.
Madam Chair?
Yes.
So I have a question. As it was described, and thank you, Mr. Lehman, I understand what you're describing. I am not sure that the bill as came before us does anything different from what you've described. I understand what you're saying, that now this specifies fentanyl only, but I'm not sure that the bill as written would have increased drug use or allowed for any expansion of sales of illegal drugs. So while I would prefer to see the bill as originally, as it came to us, because I do believe it's important to harm reduction, I'm wondering if we wouldn't also want to include some line about xylazine, because that was the other thing that was brought up very frequently, but in testimony, that was one of the things that was needed to be tested for. So I don't know enough about how we would write, I just think that's something we need to consider.
Okay,
Madam Chair?
yes.
So I would agree with Senator Chamley, and I think she's identifying why the original version, I think, is a better version, because the whole point is to be nimble and responsive to whatever drug might be, appearing, I guess, in the market. So, at this point, we are seeing a lot of overdoses on fentanyl, and so I'm glad to see that. Of course, we heard a lot of concerns, as Senator Chanley identified, with xylazine, but what if it's a different drug, next month? So that's why I think the original version sort of hit the nail on the head a little bit better. If, the committee wants to refine it a little more, I certainly would want to add xylazine into this language.
Okay. Well, this bill is not a fiscal note bill, so we can hold this for another week.
Great.
And see if we can craft an amendment that would address that issue. Thank you. Okay. Let me do this. Okay. Next, we have House Bill 321, which is relative to minutes from non-public. There is an amendment. So let's get, I'm going to make an emotion of ought to pass.
Second.
Seconded by Senator Whitley. And I would like to introduce amendment number 1491S. And again, have Mr. Lehman walk us through the amendment.
This is an amendment that is intended to make no substantive change in the bill whatsoever, but the way it was written and the way it came across, I found it to be impenetrable. So it is strictly intended to be stylistic and to make it easier to read. Of all the RSAs on the books, the right to know law is the one most often used by ordinary people and should be most accessible and easy to read. So if anybody reading this looks at the bill that passed the House and this amendment and finds something that's a substantive difference, by all means point it out, but it was my effort to make it easier to read and nothing else.
Okay. So are there any comments on, Matthew, do we have a motion on the amendment?
Someone needs to move. the
Okay,
amendment.
I'll move on to pass on amendment 1491S. Is there a second?
Second.
Seconded by Senator Chandley. Is there any discussion on the amendment? It seems pretty straightforward. I think it's, quite frankly, it's probably a little easier to read.
Yeah.
Okay, so we have a motion of ought to pass on amendment 1491S. Is there any further discussion? All right, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, so the bill has an ought to pass as amended motion. Is there any further discussion on the bill as amended?
Can I just make one last comment about that? When I say it's hard to read, I don't, that's not directed at anybody in the House who worked on this bill. The right to know law has been through so many iterations and gets amended. It just becomes difficult to read through nobody's fault, just through constant change. So I didn't intend anything I say to be a criticism of any of the work done on it by the House.
No, it's, Mr. Lemon, I didn't take that as criticism. And it's because of the comment you made about that particular statute being pretty convoluted. This made it easier for this to be read. So that was my comment. Okay, so we have a lot to pass as amended motion. Is there any further discussion on House Bill 321? Okay. Seeing none, all in favor say aye. Aye. Any opposed? Okay, is there a motion for the consent calendar? So moved by Senator Ward, seconded by Senator Gannon. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Senator Chamberlain, would you like to do this
Sure.
one?
Yes.
Okay. Next, we had House Bill 343 relative to the release of confidential records of a person appointed a guardian. I have ITL. I'm going to move ITL. Is there a second? Seconded by Senator Gannon. I think this bill really tried to get somewhere. I'm just not sure that it got exactly where it needed to go. I had a lot of concerns about the guardianship. If you remember, a couple of years ago, we passed a law that made guardianship a lot easier for folks, that would allow the guardian to be to participate more in their guardianship. And I just don't know if this is where we really want to go, to allow a ward to access their records unless a court determines it would not be in their best interest to do so. I can't imagine not having access to your records and having a court determine that. I think that might be something that should be worked out between the guardian and the ward, and using that new procedure that we set up. So, are there any, Senator Whitley?
Yeah, I actually thought that this bill was definitely ready for prime time. I think the law is silent on access to records for guardianships. I think what we did before on supported guardianship was excellent, but I think this is a different situation. I think this is just, strict, traditional guardianship. And, I think it's important to have flexibility within the guardianship statute, just so, if someone has, someone doesn't have all their rights removed if it's unnecessary. And I think, it's very likely that someone, an individual would want to gain access to their records. And if they don't have any sort of guardianship limitations on that right, I think they should be able to access to them. So the Disability Rights Center had worked on this, Attorney Tasker, some very smart folks had worked on this to provide just some clarity to prevent, individuals, from not getting access to their records. I think we heard some evidence that it is happening. And I think this bill would have been an important piece of legislation for people with disabilities, so they would have access to their records. So I'm disappointed we can't pass this.
Okay, are there any further comments, further questions? Normally I would agree with you, but I just don't think this bill is ready. I think it needs just a little bit more work. And I'm just gonna move there, so. Okay, so we have a motion of ITL on House Bill 343. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Opposed?
No.
Okay, I'll take this one to the floor. Matthew. Okay. Next, we have House Bill 360, an act legalizing cannabis for persons 21 years of age or older. I will move ITL.
Second.
Okay, is there any comment on House Bill 360? Senator Whitley?
Yeah, I would say that, this is a very simple bill. It just, removes possession of cannabis as a crime. We've heard some harms that have come to to community members because of this. So I think this was a simple bill. This should be the next step that we have from decriminalization. I think this should have been an easy next step. So I'll be voting against the ITL.
Okay, thank you. Are there any further comments or questions on House Bill 360? Okay, seeing none, we have an ITL motion. All in favor say aye.
Aye.
Aye. Any opposed?
No.
Senator Chandler, do you?
Sorry, no,
Okay.
I apologize.
Okay, Senator Gagnon, you want to do this one? Okay. Okay, next we have House Bill 376. This is establishing a committee to study the current education, training, and requirements for personnel employed as emergency dispatchers and 911 telecommunicators for police, fire, and emergency medical organizations. And want to move, I ought to pass.
Second.
Seconded by Senator Whitley. Is there any discussion on the ought to pass motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent?
Senator Whitley moves consent, seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Senator Whitley, do you want to do this?
Sure.
Okay. Okay. Next, we have House Bill 379, requiring notice to be provided to tenants during residential eviction proceedings regarding legal counsel. I'll make a motion to retain this bill,
Second.
seconded by Senator Gannon. When we had the public hearing on this, the parties were going to get together and they were going to try to come to some sort of resolution. I don't believe they had enough time. They weren't able to get that done. So it was either to ITL it or re-refer it. I would prefer that we will refer it to give them the time they might need to come to an agreement. Okay, so we have a motion of re-refer. Is there, we already have a second, okay. Is there any further discussion on the re-refer motion on House Bill 379? Right, seeing none, all in favor say aye.
Aye.
Any opposed?
Move consent?
Okay. Senator Whitley moves consent. Is there a second? Seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Senator Ward, would you like to do this? Okay.
Can we have a 2-minute break? Can I just had a
Sure.
question for you?
Okay, the committee will be in recess for 5 minutes.
I'm just a problem. Can I stay? Oh, I can ask you here. I just had a question for you. Okay.
Okay. the committee will come out of recess. We're going to begin with House Bill 397. I'm going to ask that the committee re-refer this bill. It needs some more work, and our colleague, Senator Gannon, has asked that we hold this so he can do the work. Senator Whitley.
I think that this bill was ready. I think it was just a very simple clarification. You know, we heard such compelling testimony from a mom, you know, who didn't want her minor children to be, you know, convicted of a crime. So I think this bill is very simple. I think it's ready for prime time. Maybe if we want to hold the bill for a couple of weeks, I would support that. But I definitely think this bill was ready. And I just don't want to, I think there is a timeliness to this issue because we're talking about kids here. And we just don't want to put our children of, you know, who have parents who have diabetes, we don't want to put them in a bad situation. So I do feel some urgency in this bill.
Senator Chandler.
And my question is similar. I'm wondering if it's something that can be worked on without a re-referral. I don't know what Senator Gannon's concerns are. I had concerns when I read the bill, and I did reach out to the Medical Society and got information back that their leadership was good and thought this was a good fix for the situation as it exists right now. So I would like to see this passed. I'm wondering if it's something that can be addressed in a fairly short time.
Right. Not a fiscal note bill.
No. Senator Chandler. No, he'd like to retain it, so. Okay, so we have a motion of re-refer.
Someone has to make a second.
Oh, is there a second? Senator Gannon. Okay, so is there any further discussion on the re-referred motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed?
No.
Okay, Senator Gannon, you want to take
Sure.
this one out? Okay, next we have House Bill 431, permitting qualifying patients and designated caregivers to cultivate cannabis for therapeutic use.
Motion for ITL.
Okay, Senator Gannon moves ITL. Is there a second? Seconded by Senator Ward. Okay, is the discussion?
Madam Chair?
Yes.
This is a really important bill. We have had medical use of cannabis for a good while now, and one of the things that has come to light every time, every session, is the difficulty for some patients to access therapeutic cannabis at the facilities that are designated, either because it is too expensive or the facilities do not carry the strain that is needed, or that the distance to travel, especially if you're ill and in need of therapeutic cannabis, traveling a great distance can be prohibitive. This bill, I think, has the necessary guardrails. It's a well-drafted bill. It was presented to us very it was compelling testimony that we heard during the public hearing. I think it's really important that we consider this. I know that we heard this bill or similar bills in the past, both probably it has been heard in maybe in Health and Human Services and Judiciary over the years. We really have to recognize that insurance doesn't cover therapeutic cannabis. So for those folks who cannot afford out of pocket, homegrown is the alternative. And I hope that we can recommend this.
Are there any further comments on House Bill 431? Okay, seeing none, we have an ITL motion. All in favor of the ITL, say aye.
Aye.
Any opposed?
No.
Okay, so we have 3-2. I'll take this one out, Matthew. Me. Okay. Next, we have House Bill 473 relative to penalties for controlled drug violations.
Motion for ITL.
Senator Gannon moves ITL, seconded by Senator Ward. Okay. Discussion, Senator Whitley.
Yeah, thank you. I think this was a really good bill. We have heard this issue before. I think that, this, I think we have to understand when thinking about this issue that felony convictions have serious collateral harms, right? Particularly when we're talking about, in this situation, we're only talking about first-time possession. And, when we look at saddling people with felony records, what I hear for supporting that is that it will keep our communities safe, but the data is just not there to support that. I think there's really compelling data showing that deterrent model it's not effective. And then, this would still allow for a misdemeanor charge, which is significant. I mean, that could lead to a year in jail. And so I think it's not insignificant to have a misdemeanor charge, but I think it's overly punitive, when we're looking at how significant a felony conviction is for someone's future. If we're looking at them trying to get back into the workforce, we have an incredible workforce shortage. We know that is a significant barrier. So I think this was a really important small step, and I'm disappointed that we can't pass this bill.
Are there any further comments? Okay, seeing none, we have an ITL motion. All in favor say aye.
Aye.
Any opposed?
No.
Okay, Senator Gannon, you want to do this one? Okay. Next, we have House Bill 517 relative to background checks for surrogate parents.
I'm a vote TP.
Okay, Senator Whitley moves ought to pass. Seconded by Senator Chandler. Is there any discussion? Okay, seeing none. All in favor of the ought to pass motion, say aye.
Aye.
Any opposed?
Consent?
Okay, Senator Whitley moves consent. Seconded by Senator Chandler. Is there any further discussion on the consent calendar motion? Seeing none. All in favor say aye.
Aye.
Any opposed? Okay. And Senator Chandler, would you like to do this one? Okay, the last one we're going to take up today is House Bill 596, prohibiting the use of racial profiling in law enforcement activities and in sentencing.
I'm about to pass.
Okay, Senator Whitley moves on to pass, seconded by Senator Chandler. We do have an amendment. Okay, it is amendment number 1497. Mr. Lehman, do you want to walk us through that?
I will, while he's pulling that up, if I may, Madam Chair.
Oh, sure.
I think the amendment, I actually think the bill as written works best. I think in particular, the amendment on line 7 changes the word to solely.
Yep.
I think that's the problematic piece. I think it removes all of the teeth to it. I think the other piece it removes is the judicial profiling. I think, that's less of an issue for me, but I think I can't support an amendment that replaces what was previously with solely. I think it's how does one determine, the singularity of someone's action. I think the way that it was written was perfect enough. So this is, I don't think this amendment is necessary. I think the way that the bill was written, I think the House had worked on it and done a really good job with it. So if there is some discussion about the need for the amendment, perhaps we can return the original version on line 7. I think that's something that might be a possibility.
Okay. Mr. Lehman, do you have anything you'd like to add?
Senator Whitley's identified the principal change, which simply has to do with quantity of evidence or the purpose of the person who has engaged in racial profiling have to demonstrate before the bill comes into effect. So it becomes just a matter of what the intention behind the racial profiling is.
Okay, I do have a question for you because it seems like this bill relies solely on solely using that particular word. And what is the difference between using solely and to any degree, which is the language in the original bill?
Well, to any degree, it's potentially, for instance, if the claim was implicit bias, and there was an inescapable part of who they were, then in theory, they're engaging in racial profiling to any degree simply by having implicit bias. There are other levels at which you could define the degree of intention that the person engaged in racial profiling has to be shown to have for the statute to have effect. It could be preponderance, it could be the primary motivating factor. There's a lot of different formulations you could use, but how do you tease out that an intermediate quantity? I think becomes complicated, but not simple.
Madam Chair?
Yes.
So it seems to me, walking into this discussion, I liked the bill as it exists, and I still like the bill as it came to us. But would it not resolve the problem that we have to just remove that language entirely and simply say, shall mean the practice of relying on race? Does that not resolve all the issues that we have and leave it, I'm not saying it won't be open to interpretation, but we won't be trying to quantify something that is not necessarily quantifiable.
Yeah.
Well, maybe, or maybe not. At some level, in the other discrimination contexts, there's, for instance, in employment, there's such things called mixed motive. A person has a legitimate motive and an illegitimate motive. It becomes a legal question whether the illegitimate motive becomes first and foremost, or whether the legitimate motive, any legitimate motive, is enough to justify the action.
Madam, can he finish?
That's all.
Oh, okay, all right.
I mean, Madam Chair, I would think that any degree of racial profiling should be odious to us. And so that's why I would agree, either keep it at to any degree, or as Senator Chanley suggested, just remove that language together. Because I think it should be odious to us that there's any racial profiling. And so if that's the policy, then I think that's what we should state.
Okay, because if I may, when we use the word solely, it would be that if someone is stopped, that they're not stopped based on their race. This is the one thing, or their ethnicity, their color, their national origin, nationality, language, sex, gender identity, sexual orientation, political affiliation, religion, or socioeconomic status or disability. That is not the one reason why that they're stopped. And that's why I think that when we talked about it, the word solely became the word that we thought that was going to fix that. That's it's not the reason that someone is stopped. There's another reason why.
But I think that by saying solely, we are allowing too much, for lack of a better term on my part, wiggle room. You can always suggest that it wasn't solely on that. But to remove solely, I think, does resolve some of our problems. And I think that we also do know that, race is a factor and the other conditions listed, that some people are discriminated against based on their ethnicity, their color, their national origin, sexual orientation, and so on. And this, to just say we don't allow it and not get into trying to quantify or measure, we don't allow it, it's not allowed. In 2023, I think that's the bare minimum, just to say, it is not acceptable. And I don't have in front of me, but I'm wondering what the statute that was passed last biennium that apparently says that motorcyclists
Yeah,
cannot
I
be
got it.
profiled. Does that
Yeah.
use
It,
language?
it says, motorcycle profiling prohibited, no state, county, or municipal law enforcement agency shall engage in motorcycle profiling. In this section, motorcycle profiling shall mean the use of the fact that a person rides a motorcycle or wears a motorcycle-related paraphernalia as a basis for deciding to stop and question, take enforcement action, arrest, or search a person or vehicle under the United States Constitution or the New Hampshire Constitution.
So I think that does get to what Senator Chamley is saying. I think in that statute, they're not saying, asking, to quantify anything. That's why
No.
I think, and also I think in the spirit of compromise, I would like to see the bill as original, but I think we would be, I'm not gonna speak for Senator Chamley, I would be okay with, at this point, removing the judicial portion of it and, but keeping in the very strong statement that, the New Hampshire Senate doesn't believe that racial profiling should be acceptable. And I think if we just take out the term solely or take out the term to any degree, I think we get there.
Okay. Okay, well, again, we can hold this till next week because we've held a number of other bills and,
Can I raise one more question about the bill? And I think
yeah.
it's not obvious at first, but it plays back into the solely any degree question, and that has to do with Roman numeral 2 in lines 18 through 25. And in thinking about it, I sort of thought of this hypothetical. Imagine a world in which a person gets mugged by a person, and in the immediate area are 3 members of racial group number 1, 3 members of racial group number 2, and 3 members of racial group number 3. And the victim of the crime says it was definitely one of the guys in racial group number 1. If there's 3 of them there, the provisions in 18 through 25 require there to be reliable information relevant to the locality and time that links a person to an identified criminal incident or scheme. Based on the victim's description of who's in the area at the time, we don't have a person, we have 3 people, and you need to be relying on the person's race to winnow down the list of potential suspects to the 3 people who are there and eliminating the other 6, and that's relying on race at a time when you don't have a single person identified as a perpetrator, you just have a narrowed group based on the victim's identification at the time. So that's where, if it's, I think that at that point, nobody is being identified solely because of their race. They're being identified by also by their presence, and you want the investigation to go forward at that point.
Yes, Senator Whitley.
Well, I think the issue that you're identifying is addressed by lines 18 to 21.
Right.
Because those are the prohibited acts. So it says nothing in paragraph 1 shall be interpreted to prohibit a law enforcement officer or law enforcement agency from relying on physical descriptions, yada, yada, yada. So that solves the issue that you just identified, I believe.
I don't think it does, because it says unless there's information that links the crime to a person, and it's being linked to 3 people based on their membership in a racial group, but also the time and place and location that they're there, and the identification, the partial identification, obviously, of each of 3 people.
I mean, I think we have to establish sort of a threshold that we find racial profiling problematic and we don't want to allow it. And I think removing the, degree language gets us there. We have a strong statement. We're taking away sort of the degree to which it could occur and saying we should not be racial profiling in New Hampshire. That should be an easy one, I believe.
So would you want to hold it for a week and let us?
I think we can hold it.
Great.
Mr. Lehman, my concern is where it says if we're going to take out to any degree or solely, the practice of relying that particular language there. What does it mean to, in legal terms, to rely? Is that going to conflict with lines 20 through 25? Because if they're going to rely, they've been given a physical description of someone who has been accused of committing a crime, and the police, they're going to rely upon that description. So they are automatically going to throw the race category out, and then look at the rest of the categories. Am I correct?
I am not sure.
Okay. Okay. All right. So we're just gonna hold this one. We'll hold it till next week. Okay. So, we have completed our work for today. I'd like to thank everybody for being here. We appreciate it. And I will take a motion to come out of executive
So
session.
moved.
Okay, and I'd like to thank Senator Ward very much for being here today. I know. Well, we had to do that in, with Senator Bradley. We gave him one.
That's good.
So she got a homework assignment, so. Okay, the committee, all in favor of coming out of executive session?
Aye.
Aye. Okay, thank you all. Okay. Yeah, be careful. Just be careful.